You can find the first video in this link that I sent you in chat. And I don't remember if I announced that, but I will be in the classroom. I think it is 6th of December. So the third remark on the classification of legal effects is about the legal effects of a treaty for other international norms, for other international legal norms. And there will be an analysis about the relations between a treaty and a custom, and then relations between a treaty and another treaty. The first relation, normative relation, is about treaty and custom. We will see what is a custom next week. I think we will talk about custom. The international custom is a repeated behavior of legal subjects, states or international organizations, which is considered by those legal subjects as mandatory, as binding, legally binding. So, how can we analyze relations between a treaty and a custom? There is no real principle of hierarchy. There is no strict principle of hierarchy in international legal order, in contrast with the national orders. In national orders, we have a strict approach of the principle of hierarchy. For example, we have constitution, the supreme norm, and then we have other norms, rules, and executive rulings. For example, we have a hierarchy in national orders, which make national orders rule of state. National orders are orders of rule of state. Hukuk devleti. Hukuk devleti dediğimiz içinde hiyerarşisi, normların hiyerarşisinin kesin kez tanındığı, uygulandığı devlet. But in international legal order, there is not a such hierarchical approach of norms. Treaties and customs have same legal values. The principle, normative principle in international legal order, the principle who regulates relations between norms, international norms, is the principle of equivalence. The principle of equivalence, which means that international legal norms are equivalent, have equivalent values, legal values. There is no strict hierarchy. It is true and not true same time. It is true that there is a principle of equivalence and generally there is no hierarchy, but there are some hierarchical relations um, also. And I will give you two examples, and you will understand that very specific cases. So, why in international legal order we speak more about the principle of equivalence than about the principle of hierarchy. Two examples of hierarchy. The first example is the Article 103 of the United Nations Charter. I'm trying to find this charter, and you will. According to the according to this Article 103 of UN Charter, there is a hierarchy between UN UN Charter, which is an international treaty, and other treaties. Because according to this Article 103, as I sent you in chat, if there is a conflict between UN Charter and another international treaty concluded by a member state of the UN Charter, the UN Charter shall prevail. It means it shall have primacy. It shall have primacy against the other international treaty. So in this case, yes, there is a hierarchy between UN Charter and other treaties, but this is very specific. It is not a general principle of international law. The second exception is the case of jus cogens. Jus cogens rules. What are jus cogens rules? Jus cogens rules, those are rules described as being always mandatory by the international law. For example, if you have a definition in the Article 53 of the Vienna Convention, which announced that those are peremptory norm of general international law. A peremptory norm, jus cogens, are peremptory norms of general international law, which mean that a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm on the same character. So jus cogens can only change another jus cogens. jus cogens is a very important international norm admitted as jus cogens by the whole of international community. For example, so there is no illustration in Vienna Convention. We don't know which rule is a jus cogens rule, but it's very rare. It's very few. There is no much jus cogens norms. There is no decisions about it, but we have an international Court of Justice decision in 2012 about the prohibition of genocide. The prohibition of genocide is considered as a jus cogens norm. So it's so much important. This norm of prohibition of genocide is so much important, then it is considered by the International Court of Justice as a jus cogens norm. And what is the legal consequence of that recognition? The consequence of that recognition is that no treaty is valid if it is against a jus cogens norm. The treaty will be void if it is against a jus cogens norm. So you can see that from this relationship, from this normative relationship, starts the hierarchy between treaties and jus cogens. This is the second exception. So there is an exception to the principle of equivalence. And the first exception, there are two exceptions. The first exception is the Article 103 of UN Charter. And the second exception is jus cogens norms. But those two exceptions are very rare. The general rule of international law is the equivalence of norms. So treaties and customs have, in principle, same legal value. They have same legal value, and so if there is a conflict between a treaty and a custom, we cannot resolve this conflict by the application of the rule of supremacy or by the application of the rule of primacy. We need another resolution rules for a conflict gathering a treaty and a custom. Those rules, there are a lot of rules of conflict resolution between equivalent legal norms. I will give you two examples. The first example is the law of posterior. Law of posterior means that the norm which is adopted lately will prevail. The norm adopted lately will prevail against the norm adopted before this lately norm. So if there's a norm in 2020 and there is another norm in 2024, if there is a conflict between them, this is the lately norm, norm of 2024, which will prevail. So the relationship between treaties and customs can be resolved in case of conflict with the norm of law of posterior. Law, why I call it law of posterior, is the rule, Latin rule, posterior derogat prior. This is the Latin formula of this conflict resolution, the first conflict resolution rule. The second conflict resolution rule between equivalent norms is the spatial rule, the law of spatial rule. Which is in Latin called lex specialis. Lex specialis. Lex specialis derogat generalibus means that the spatial law will prevail against the general law. For example, I have an example, concrete example in the case of Jathao case before the International Court of Justice concerning consular diplomatic relations between states. And of course, the spatial treaty about embassies, about diplomatic relationships will prevail a general custom about relations in international law. In Jathao case, before ICJ, case of 2019, you see that the spatial treaty will prevail the general custom. I would like to finish this first point, the conflict between a treaty and customs, by making an observation about the codification of customs. As I told you at the beginning, the Vienna Convention is a good example of this codification of international customs. A treaty can formulate an international custom. If it is the case, the formulas of this treaty will interest all member states of the international community. This is the case for Vienna Convention of 1969. It is a codification of customary international law of treaties. So the Vienna Convention is also important for all states, even though they didn't sign or ratify this convention. It's enough for this relationship between treaty and custom. The second point of legal effects between norms is the relationship, normative relationship between treaty and other treaty. Don't forget that all resolution rules that I announced to you are applicable in this case. For example, Article 103 of UN Charter. It resolves eventual conflicts between treaties and this charter. Another example, lex specialis rule, already announced. If there is a conflict between a general treaty and special treaty, the special treaty will prevail. For example, if there is a conflict between a treaty on human rights and another treaty on humanitarian law, the humanitarian law treaty will prevail because it's more specific than human rights. And also, lex posterior rule, the time when a treaty is adopted, can help to resolve conflicts between treaties. There are other rules, other examples in the Vienna Convention, but I don't ask you to know them. For example, we have the Article 30, according to which the resolution of successive treaty is determined, but it's not too much important. It's very technical, so it's okay for me that you don't know that. So we saw our first point, the classification of legal effects. That was all I want to say about the classification of legal effects. Let's talk very quickly about limits to those legal effects, which is my second point of my lecture. Legal effects of treaties, international treaties can be limited by many legal situation. The first situation, I have a lot of situations, but I won't do every situation, okay? I will talk only about main situations. The first situation is reservations, declarations, annexes, protocols to international treaties. Reservations, declarations, annexes, and protocols to international treaties, which means that mostly for multilateral treaties, mostly for treaties with more than two states, several states can make reservations or declarations in order to limit the effect, the sense of their international obligations. For example, Turkey made some reservations against the European Convention on Human Rights, but several reservations of Turkey was considered as illegal, as void. So it wasn't possible, for example, for Turkey to exclude the Northern Cyprus situation from the scope of application of the European Convention on Human Rights. This is the first situation. States can make reservations or declarations in order to limit the sense of their obligations existing in international treaties. The second situation is that the fact it's a legal rule according to which, according to Article 28 of the Vienna Convention, according to which a treaty cannot be retroactive, a treaty cannot be applied to the past, to situations which occurred before this treaty. The most important example of that is the genocide treaties. Genocide treaties, treaties about the prohibition of genocides, cannot be implemented to situations before their conclusion, cannot be retroactive. If you are interested about this subject, there is a case law between Croatia and Serbia before the Court of Justice, International Court of Justice, in 2015. And you can check at the paragraph 95 of this decision. You can easily check it on Google and find it on the website of the International Court of Justice. The third situation which can limit legal effects is the situation of amendments, revisions, modifications of the treaty. A treaty can be amended, can be modified, can have reservations. The fourth situation is the suspension of the treaty. A treaty can be suspended. For example, the European Convention on Human Rights allows in its Article 15 the expansion of some rights in case of emergency in member states. A state can suspend human rights in case of emergency. It can be suspended. The European Convention on Human Rights can be suspended, not every right. For example, right to live, right, the prohibition of torture are not suspended. They cannot be suspended. But other rules, for example, free speech or property, rule of property, right to a property, can be suspended. The fifth situation is that a treaty can extinguish, the extension of the treaty can be extended. It means that, for example, the Coal and Steel Community Treaty was concluded only for 50 years, so it is extended, it is finished in 2002. The Coal and Steel Community Treaty, Paris Treaty of 1952. And the other situations are possible. For example, denunciation of a treaty is possible. A state can denunciate a treaty, reject a treaty, and then withdrawal of a member state is possible. Withdrawal from a treaty Sorry. I'm trying to, yes. Withdrawal from a treaty is possible. For example, Article 50 of Treaty of European Union allows the withdrawal of a member. For example, the United Kingdom Brexit is an example of withdrawal. Another example of withdrawal is the withdrawal of Russia from the Council of Europe after the Ukrainian war in 2021. So treaties can be limited in their binding effects. There are other rules which are limiting those treaties, but I won't talk about them. So I will finish this lesson. Thank you very much for your attention and see you next week. And good luck for next week. So we don't have lesson, I don't know. I will ask to the administration. Good luck for next week. Thank you very much.